Hello, everyone. Welcome to today's webinar on preparing for golden years. Get to know your legal instruments, documents, and processes. This webinar is part of the Law Awareness Weeks at CDC2021, a collaboration between the Law Society Pro Bono Services, the 5 Community Development Councils, NUS Faculty of Law, SMU School of Law, Singapore University of Social Sciences School of Law, the Singapore Corporate Counsel Association, and supported by the People's Association. My name is Sarita Misir, and I will be your host for today's webinar. Before we begin, I just want to run through some housekeeping matters. First, feel free to ask questions at any time during the webinar using the Q&A icon at the bottom of your screen. We will do our best to address your questions during or at the end of the talk. Second, there will be a QR code featured at the top left-hand corner of the slides for you to scan to access the handouts for today's webinar. A link will also be found in the follow-up email to be sent to you tomorrow. Third, please note that the discussion and any material provided in this webinar is not intended to substitute or constitute as professional legal advice. You should always consult a lawyer if you require specific legal advice. With that done, let me introduce our speakers for today's talk. On our panel today, we have Tan Shen Kiat and Dr. Liana Zailan. Shen Kiat has often been described as a combination of a lawyer and social worker by those that he has worked with. He believes sleep is often underrated and he needs at least 8 hours to behave humanely for the day. He's a delighted co-founder at Keith and Kin Law Corporation, which is a dedicated STEM law practice in estate planning and later life planning with a mission to help healthy families stay strong. Dr. Liana is an associate consultant in general medicine and specialist trainee for palliative medicine in Woodlands Health. She attended medical school in NUS and has been in both hospital-based and community medicine practice for the last 11 years. She currently works in palliative care, consult services, and hospice care services in various institutions in Singapore. Her interests include collaborative healthcare decision-making, enhancing communication skills, and palliative care education at all levels. Thank you both, Shen Kiat, Dr. Liana, for joining us today.
Thanks, Sarita.
Yeah, thanks, Sarita, for having us.
Yeah.
Okay, so why don't we move into the why first of why it's important to plan ahead, right? So our audience members, we all know that Singapore has one of the highest life expectancies in the world, but unfortunately also one of the lowest total fertility rates in the world. So this combination inevitably means that we have a rapidly aging population. And despite advances in science and healthcare and medicine, right, none of us are immune to serious illness, prolonged suffering, ultimately death. This has been traditionally a taboo topic, right? But it's also important to think about planning ahead because planning ahead allows us to make our wishes clear to our family and loved ones. It also helps to relieve stress faced by our loved ones, who studies have always shown are unlikely to accurately predict what we want for our care if we do not have that discussion with them beforehand. This also helps us, planning ahead also helps us by giving us control of the time that we have left, right? So then let's move into the how. In today's discussion, we will be bringing together some of the major hows or ways of planning ahead. We will be talking about wills, lasting power of attorney, advanced medical directive, and advanced care planning. So let's move into our first how, which is wills. A will is a legal document that sets out how our assets should be distributed after death. Shen Kiat, can you briefly explain the requirements for a valid will and what should be included in it, and also what cannot be included in it?
Wow, Sarita, thanks for that. That's a lot of questions in one sentence. So essentially, a will, as we all know, is a legal document that allows you to indicate how your estate under your sole name is to be distributed and how to be distributed when you passed on. So well, there are formalities for executing a will, but we as lawyers mainly classify them under two types. The first is what we term as formal validity requirements. Formal validity requirements basically deals with the technical aspects of executing a will. So for example, a will needs to be signed right at the end by, the testator himself or herself. Needs to be witnessed by two independent witnesses who are neither the beneficiaries in the will or the spouses of the beneficiaries in the will. And obviously the testator needs to be 21 years old and above as well, and so are the witnesses too. So these are some of the what I would term the formal validity requirements for executing a will, which the audience shouldn't be worried about if they go to a practitioner, really, right? Then we have the substantive validity, right? The substantive validity deals with the contents therein inside the will itself, whether the clauses inside the will, are they enforceable or not? Do they contradict any public law? Do they contradict any understanding of what we know about the manner of how certain assets are held? Like, for example, jointly held property, for example, which actually brings me very neatly to answer the question, right? What can be included inside a property and what can be included inside a will for distribution and what you can't? Essentially, I think I'll start with CPF. CPF is the easiest to explain. So CPF monies, they belong to you. They are protected from creditors, but you cannot distribute by the will, right? It's both a public policy issue and it's also a legislative mandated thing. So in other words, to distribute your CPF monies, you need to make a nomination. There is at least 3 different types of nominations you can make. There is the normal nomination, which basically allows a check to be made by CPF to your nominees. There's also the enhanced nomination, which basically means that your CPF monies will be transferred from your account to your nominee's CPF account, right? So there's a slight difference over here. And then the third is what we call SNSS scheme. It's mainly used for caregivers with folks with special needs, and they want the monies to be fed through a trust company, like a special needs trust company, for example. The nomination can be made online, so that's quite straightforward. For the first one, the other two, you need to go down to the CPF branch to do that. So anyway, so CPF monies is excluded from distribution via a will. The second would be insurance, right? So insurance with valid nominations, they are excluded from distribution via a will as well. So in other words, if you have insurance and there's no valid nominations made, the insurance proceeds will be distributed via the will. For insurance nominations, and especially those policies that are purchased post 2009, there are basically 2 types of nomination: irrevocable and revocable nomination. As the term revocable nomination, implies, you can change the beneficiary, right, of your insurance process anytime you like. This year I like, person A, so I make person A my nominee, right? Next year I realized that, the other person treated me better, so I decide to change my nomination. So yeah, you have the freedom and the autonomy to change the nominee. Whereas for irrevocable nomination, it's basically a one-off nomination that you made to your spouse and or your children, right? So it's very specific and it's irrevocable, meaning that you need the consent of your successful nominee before you can change or before you can revoke or change the nomination, right? But I think the bottom line is insurance in nominations, they are not distributed via the will. The final item that is excluded from distribution via will be jointly held assets. So for example, bank accounts that are under joint names, whether is it under the joint / alternate, kind of manner of holding, it doesn't matter, right? 9 out of 10 times is excluded from distribution via the will, okay? Jointly held properties as well. So for those of you who are homeowners, your property, if you are owning the property, co-own the property with someone else, then there's likely to be 2 types of ownership we are looking at. The first is what we term joint tenancy. The second will be tenancy in common. So for joint tenancy, basically A and B, their names are on the title deed. They both own 100% of the property. So if A passes away, assuming that the mortgage has been fully discharged, then B will own the property outright, right? This in the absence of any will in that sense. For properties that are held under what we term tenancy in common, it's slightly different because the share has been clearly delineated. So tenancy in common could mean that A could hold 50 and B could hold the other share in 50, right? Or it could be 90-10, 99-1. Because the shares are clearly delineated, we can identify the ownership of that particular asset. And hence, you can distribute that particular share via your will in that sense. That's really in a nutshell what you cannot distribute via your will actually. And I guess the rest means you can. Yeah.
Yeah, thanks, Shinket. I think, going back to your point about the formalities, right, and the substantive kind of validity as well, right? I think, we have a lot of questions from the audience during the registration phase where they were talking about, those do-it-yourself, right, online will writing services, right? So can you just talk a little bit about whether if you do it yourself or you use those online will writing services, are the wills valid? Or whether you've seen any, issues caused by using those kind of services.
Right. Thanks for the question. I think it's an important one. There's nothing to say that DIY wills cannot be valid or are invalid, right? They can be valid as long as they follow the technical formalities of execution, right? So we get that out of the way, right? DIY wills can be valid provided they are executed properly. But increasingly, we have seen situations where such DIYs are not executed properly. And generally, when we admit a DIY will for probate and the will is not witnessed by a solicitor, the court tends to ask for this additional document called affidavit of due execution. Essentially, affidavit of due execution is a document that requires the independent witnesses to the will to testify, right? To attest to under what circumstances was the will executed, right? And that's because there's a presumption that unless the will was witnessed by a solicitor, lay people may not be fully aware of the requirements under the Wills Act. So we actually had a case sometime back earlier this year where I had a client who tried to use one of those DIY online bank will generator kind of thing, right? And happily came in thinking that, because he had done some work, we were charging him a little bit less, right? So he had his wills witnessed by his family members, specifically the spouse of the beneficiaries, who were then his only two sons, right? And if you guys are aware of what I mentioned earlier during this webinar, right? For independent witnesses, they cannot be the beneficiary themselves, and they cannot be the spouses of the beneficiary. But unfortunately, the FAQ on this particular DIY website actually did not indicate that spouses of beneficiaries cannot be a witness, right? So that's a problem over there. And number two, we realized that the witnesses signed on the document on separate days. So that's also a no-go, right? The Wills Act, part of the formalities requires all parties, the testator, the witnesses, to be present at the same time and having witnessed each other, put their wet ink onto the piece of document. So these are some of the issues, from this part that we see with DIY wills. So if you have eye issue, you go to an eye surgeon, right? Or you have a wills issue, you go to an inheritance law expert, I suppose, right? That you will have all these issues anymore.
Yeah, thanks, Shanket, for that. Shanket, if you recall, we also had during our prep stage, right? I think we also had a question about what happens to wills or inheritance related issues, right? When you're talking about mixed marriages, right? Which are pretty common now in Singapore and getting even more common, right? I think, yeah. So can you very briefly, just tell us about, what happens in a mixed marriage?
Oh, wow. Mixed marriages. So generally speaking, right, in Singapore, whether is it mixed marriages or not, I think that's fine, right? I think the first general rule of thumb is all of us have the freedom to choose who and how we want to, distribute our estate. That is the number one principle, right? The issue with regards to mixed marriages only arises if one party happens to be a Muslim and the other other half of the couple happens to be a non-Muslim. And that's where certain inheritance related issues may arise, because for Muslims who are domiciled in Singapore, domiciled meaning someone who treats Singapore as their permanent home, right? Singapore inheritance laws will apply, and specifically Singapore Shariah law will apply to how the estate will be distributed. So very quickly, Shariah law has a different way of dealing with the distribution of Muslim assets in Singapore. And specifically, you can only give up to 1/3 of your Muslim friends can only give 1/3 of their estate to what we term non-Faraid members. Essentially, Faraid members are a predefined set of next of kin who can inherit the estate, right? So they can give only up to 1/3 to non-Faraid members. So in other words, this means that in a mixed marriage involving a Muslim and non-Muslim, the non-Muslim member subject to the assets that are excluded via the distribution of a will or wasiat under Sharia law, that they will only be able to receive up to 1/3 of their husband or their wife's estate. So that poses some issues, right? Especially with estate planning for these mixed couples. There are solutions to this, but as you said, we're supposed to talk about this briefly, so I'll just leave it at this for now.
Yeah, maybe Shanket, on this point, right, regarding Muslim or Sharia law rather, and inheritance issues, right? There is a question from one of our audience members about. Sure. So the question is, if I'm Muslim, must my will be executed in accordance with Sharia law? Is there a way to opt out of Sharia law so that civil law applies for my will?
Right. That's sure. That's a great question. I will give the most honest and the most frank answer to this question, which is, if you want civil law to apply, right? What some of my Muslim clients actually do is they renounce their faith via a statutory declaration, which has to be submitted to MUIS, right? So once they make the renunciation, then civil law will apply to their estate, right? But obviously, that may have some knock-on issues, because if this person who renounced their faith actually have surviving elder family members who are Muslims, that means that they will become a non-Faraid member, right? In respect to maybe their parents, or their siblings' estate. So before you do something like that in the context of estate planning, you need to consider carefully whether that's the right option for you. There are also other Sharia law compliant legal instruments. We commonly call them hibas and nusrias, for example. Without going into too much detail, they allow assets to be redirected to certain specific beneficiaries. They may not conform to how the Faraid will deal with it in a Sharia law compliant manner, right? That said, some of these instruments are not tested against the civil law, so it is a gray area, I must admit. But there are definitely solutions to deal with this.
So I guess the advice in that case would be to see a succession lawyer like yourself, right, to get proper advice on this kind of issues.
Yeah. I mean, that's definitely a start, right? You don't know what you don't know, really. If I just quickly add, like things like CPF nomination, for example, right? They fall outside the Faraid regime, right? Before I was, yeah. So that's one way of, sometimes I tell them clients, why don't you just put your money in CPA and you nominate who you want, right? Or you hold your assets under, joint names or joint tenancy with the people that you want to bless these assets with, right? So that is a low cost way of going around, the Sharia law system legitimately, I must say, in that sense.
Okay, thanks, Shanket. We have a few other questions regarding will, but maybe let's just go through our section for wills first, and then we can deal with those questions. So moving on to the next part, I guess, is really about, we've made a will. What if, like you mentioned, circumstances change, right? Your, executors might pass on, your beneficiaries might, maybe you have a falling out or whatever, right? So can you also explain then, what is the process to amend the will once it's already done?
Yeah,
assuming, of course, the testator, I guess, is still alive, right?
Yeah, and assuming that also the testator still has mental capacity, right? So if they're alive and they still have mental capacity, well, if they make the will the solicitor, they can always go back to the same solicitor if the solicitor is still alive and still has capacity to amend their wills, right? Because I think that's quite practical, because the solicitor will already know their background. They don't have, the client would not need to do any get out work again with someone new, and this person would know their circumstances and what's not, kind of situation. So really, as long as the capacity, you are in good health, you can amend your will. That said, we do have this golden rule for legal practitioners. That is that for any clients who are generally 80 years old and above, even if they are mentally capable, we would require a medical report, or I personally would require a medical report to be done. So I'm a little bit more conservative than most lawyers. They normally require a capacity report if they believe that the client may be of unsound mind, right? Or maybe at the borderline. Whereas in my case, as long as you are 80 years and above, and it's a golden rule found in one of the case law, I actually asked for a report as well to say that you are of sound mind, which is the opposite in that sense. I think really at the end of the day is trying to create as much context, as much information about the circumstances in which the will was executed, especially for elderly client at the particular point in time that we want to deal with, because once they pass on, there's no going back, and so we can't time travel and sort these things out in the event of a will contestation.
Yeah, so Shanket, I assume then if you amend the will, I guess it's just creating a new will with all the same validity requirements that you were talking about earlier, right?
Yeah, so there are various ways to amend will. So as Sarita, you mentioned, you can just create a new will to amend the old, to revoke. Well, you can revoke the old one and make a new one, especially if the changes are substantial, right? So for example, you are changing, the appointment of the executors, you are dealing with a reproportioning of the assets, right? They are to be distributed. You might want to create a testamentary trust, right, within the will, sort of thing. So those would generally necessitate a new will. But for certain clients, we might suggest a codicil instead. So a codicil is actually a supplemental legal document to the original will, and the codicil is very useful if the changes to the original will is minimal. So for example, I only want to change the name of the executor, right? And I think for practitioners who execute codicil, it's really also to keep the history of the testamentary changes visible, because we want to know that, hey, we're only changing one aspect. We're not changing the entire new will, which generally will be the impression that we get, like people will get when they make a new will to revoke an old one, that the contents are actually substantially different. Yeah. So yes, so you can do it by a new will or by what called codicil in that sense. And last but not least, which is something very interesting, the court also have powers to make wills on behalf of someone who lacks capacity, right? So generally, a person who's connected to this, normally a family member who lacks capacity, can actually use their position to ask the court to apply for a will to be made on this person's behalf. We normally see these situations where where we are looking at next of kin who are special needs, who lacks capacity, and estate planning needs to be done for them as well, in terms of how do we manage assets under their own name, where trusts are not created. This is really niche, and it's something that and it's only a solution that was only available 10 years ago. So yeah, so that's another way of making a will, actually. Asking the court to make one on your behalf, to make one on the person's without capacities behalf.
Thanks, Shakir. That's a lot to think about, and I think it's also I think it just brings home, right, the point that you should probably make the will and think about how you want to distribute your assets ASAP, right? But you still have capacity, you have proper executors, witnesses, people like that.
Yeah, exactly.
And then, okay, so on this point, then let's move on to the flip side, right? What happens if you pass on and you don't have a will? How is your estate, how are your assets distributed in that case?
Right. Okay. So at this point, right, I would be really honest. I think for estates that are relatively plain vanilla in nature, that means that maybe a nuclear family with 2 kids, the assets are like maybe 1 bank account, 1 HDB flat, or 2 bank account, 2 HDB flat, the kind of situation. It's not necessarily true that having a will is actually more beneficial than not having a will, and it might sound a bit controversial to say that, but interestingly, last year during our lockdown, during the circuit breaker lockdown, the family justice court, the probate registries, they were actually closed. So for my clients who actually have a valid will and we need to apply for probate, we couldn't do so because the registries are closed, right? They cannot inspect the will. Whereas for my clients who passed away without a will, and we know the schedule of assets, we know their schedule of assets, we know that the beneficiaries are like only the 2 children, we actually managed to obtain the grant during the circuit breaker, right? So interestingly, I mean, that got me to rethink some of the narratives. But essentially, I think having a will is more important. It's still important. I'm not trying to discourage you guys from doing one. I'm just saying that the Singapore court system is really efficient, right? So it's relatively straightforward to obtain what we call grant of representation. It's basically a court order that formally appoints an executor and administrator to administer a deceased person's estate. What normally jams out the application is really the applicant for the grant not knowing the full extent of the estate's assets and liabilities. That is really like the main factor that that really jams out the whole procedure, because asset tracing is a very cumbersome, very difficult exercise. Most of the financial institutions, especially the banks, they do not accept emails. They require us to write snail mail to a PO box somewhere where they will have a team of people who will at Changi Business Park who will slowly examine the documents, and then they will take maybe a month to reply you, right? And they may ask for more documentation before they reveal any information to you. So, and obviously with PDP and all that stuff, the banks are increasingly more and more reluctant to release such information to next of kin, and that's why the lawyers have to come in to request for such information. So really, I think for anyone who is thinking of sorting out the estate planning with or without a will, the first thing you need to sort out is have a proper schedule of assets, right? Have a proper schedule of assets. Make sure that your caregivers, future caregivers know what you own and what you don't own, and what's all the funding arrangements that you have. And then, then you think about whether a will is necessary, right?
Yeah, thanks, Shakir. I think we have a whole bunch of questions. I think the audience members are quite interested in issues relating to wills, right? So maybe what I'll do is that I'll try to lump some of the questions together. So we have a couple of questions on insurance policies, right? You mentioned earlier that insurance is a special creature not covered by your will, right? Because you name your or you nominate your I guess your beneficiaries,
yes.
Right?
Yes.
So one of the questions is about if I already have a will, do I still need to have a separate nomination for insurance policies? Aren't insurance policies part of my assets, right? I think you've already kind of answered this by saying that you need to specifically, you need to you can't put your insurance policies as part of your as part of your will, right?
If they are nominated already, right? If they are nominated, you don't need to pass them through the will. But sometimes clients, if they want to keep things clean, they can opt to revoke their nominations, right? And then just use the will to deal with the distribution, right? And I guess I must say that in the past, clients do make nominations because there's an expectation that insurers in nominations, the payouts will be faster. But nowadays, it's not necessarily the case. So once the advantage of a fast payout to deal with day-to-day expenses are negated, more and more clients are actually using the will as the all-encompassing instrument to deal with the distribution of their estate. And just also a very important technical point that I often get from members of the public. If you have make a nomination and you subsequently make a will, right? The will will not revoke your nominations, okay? The will will not revoke your nominations, all right? I don't care who are your financial advisors or whoever talk to you. The will not revoke your nominations unless there is a very specific phrase inside the will that deals with the revocation, right? So it's not simply a very general clause. The policy needs to be named, the beneficiary needs to be named, the policy number needs to be named, right? So you can't revoke a nomination by mistake. That's what I'm trying to say. And I think this is a very important note for executors as well, because they might misinterpret the will and how it's to, the intentions of the testator, and they might end up distribute the estate wrongly.
Yeah, thanks, Shakir. On this point regarding the insurance policy, the other question, right, is regarding honest member is asking, I bought insurance policies, but I didn't have a form or section to indicate the beneficiary. Is this how it is in practice, or did the agent just leave out this form?
I mean, okay, I just deal straight to the solution, right? Solution is you can contact this agent, whoever he or she is, and ask them for the form, right? The form can also be accessible online via the various insurers' websites as well, right? These forms are standard across the board because these forms and the format of the forms are all regulated by MAS. So you won't get any deviation. Just make sure you choose the correct form, right? Because there's a form for there's a form for revocable nomination, and there's also a form for irrevocable nomination. So make sure you know which is the correct form and fill out correct form. Yeah.
Thanks, Shakir. Okay, so let's move on then to some of the questions relating to, I guess, actual distribution of the assets, right? So one of the questions is regarding an HDB flat, right, which is owned the sole owner or the sole proprietor, right?
Yeah.
The owner has passed on.
Yeah.
Will HDB require the property to be forcibly sold off if the children are actually named in the will for the flat?
Yeah, so I think really the first principle that we have to apply would be, assuming that the will is valid, would be okay, the children, let's say there are two children, right, in the will, and the will name these two children as equal beneficiaries of this HDB flat, as an example. Then each of them will have a 50% interest in this HDB flat. Whether the interest is manifested, that means it is present in the form of being able to keep the property and having their names on the lease agreement, versus having the property sold and then the proceeds to be divided equally 50%. I think that's a matter of prevailing HDB rules and policy, right? So as we all know, you can't own two HDB flats. That is the general rule and principle. I do know exceptions to that, but they are under very, very special circumstances, right? Where it's necessary for, a very exceptional holding to occur to prevent someone from being homeless, right? So yes, essentially, if the beneficiaries already hold a HDB flat, then it's quite unlikely that they will be able to inherit that flat and not sell it. When they need to sell it, then generally we as lawyers we have this 6-year time frame, right? So you can have generally HDB will want you to sell, we want the executors to sell it within the first year. But generally we all know that if a property is sold within the first 6 years of the deceased owner's death, you generally don't have any issue with it. If it's more than 6 years, you still can sell, but we need to obtain a court order because we then need to explain why it took so long to administer the estate, especially if it's a HDB property and especially if the executors are properly advised.
Thanks, Shanket, again. Okay, so one last question before we move on to the next section, right? So the question is about a person who has died intestate. Can the person distribute the assets, or is there intestate succession kind of distribution for non-biological children, for example, stepchildren? Are they also entitled to the assets? And on this topic about step whatever, right? I think maybe you can also explain, you know, the order or the ranking, right, that the Intestate Succession Act uses, because I think some people might not know that you know, step siblings, right, might also be covered as well.
Yeah, and that's a great question. I think if you're non-biological children are generally excluded. Well, non-biological children are, well, if you want to make provision for non-biological children, the straightforward answer, you need to make a will. You cannot rely on the Intestate Succession Act, right? So that is clear, right? The Intestate Succession Act for members of the public is basically a predefined formula for deciding which, in the absence of a will, which next of kin have priority to inherit the estate of the deceased, right? I would generally see the Intestate Succession Act, well, the formula is having two parts. The first part deals with parents, spouse, and children, right? So as long as any of these characters exist, right, it will never flow to the next stage, if you get what I mean, right? So for example, if someone passes away and they left, you know, behind a surviving spouse and say 2 children, then the surviving spouse will get 50%. The 2 children will share the remaining 50%, right? If, let's say, the 2 kids, one of them had passed on, right, but they had their own children, that means the deceased actually has surviving grandchildren, then the grandchildren will stand to inherit what their deceased parent would have if not for the fact that they have passed on, right? So there are all these how should I put it, sideway flows. I don't know how to say it, but there are further conditions, right, that they are present in the text, in the statutory formula that may not be so clear to a layperson when they first read it. Back to the question on stepchildren, right? So there might be an exception where a person who is a stepchild may get to inherit the estate of someone who is of his next of kin. So this situation is very limited. It normally occurs when one of the stepchild's sibling, right? So step sibling, right? The step sibling passed on, and the step sibling has no surviving biological siblings. Okay, I repeat that. The step siblings have no surviving biological siblings. If they have kosong surviving biological siblings, then any surviving step siblings will get to inherit, right? So that's one of the interesting things that we have under our Intestate Succession Act. But seriously, to avoid doing all these mental gymnastics, which Sarita is making me do right now, while I've stayed in the hot seat for so long, I think that the best way to do is really just make a will, so that if it's still possible, right, so that you can target the giving. And if I may just quickly end with a very quick example, I have a client who passed away, and he left behind 2 children, right? So the spouse had also passed on. So he has a HDB flat, and 50% went to child A, 50% went to child B. Child A has been the main caregiver and has been, single and taking care of the father for the longest time. Child B is married with his own family, and because child B owns his own HDB flat, child A technically cannot hold the flat anymore because it's divided 50-50, right? And all along, we know that the father who passed on had wanted the child, who is the main caregiver, to actually inherit the whole flat. So thankfully, in this case, it was quite, well, we're on topic of relationship and healing, right? It's quite a strong family. So child B actually give his 50% share free of charge, like FOC, as a gift to his brother, right? Child A, so that child A can continue to keep the property and stay in it. However, that comes at a cost, because while any transfer of a property via a will is free of inheritance, well, not inheritance, it's free of stamp duties. But if we make any changes or redirect the transfer, then stamp duties will be payable. And in this case, child A has to pay buyer stamp duty on the market rate of the 50% of the portion that he's inheriting from his brother, right? That he's taking from his brother as a gift. So my point is that, yeah, the Intestate Succession Act has its quirks. It can be remedied, but all this thing will be done at extra cost and extra time to all parties, and extra stress as well, right? Because if the father had made a will and said that I give my flat to my son and the rest of my estate equally between the both of them, we will not need to come to this issue for the children and aka the caregivers.
Okay, thanks, Shankiat. I think we need to really move on then. Okay, so let's move on then quickly to lasting power of attorney, the next topic. Shankiat again, but you really need to summarize, right, this time. Can you just briefly tell us what is an LPA and how do we make one?
Sure. I think, okay, very quickly, most people confuse the LPA with a will, right? So I'm going to, summarize a will as a legal document that allows you to bless other people. Okay, right? That's quite straightforward, right? You plant a tree, but somebody else enjoys the shade, or somebody enjoys the fruits of the tree. But an LPA is different. An LPA, you make an LPA for your own good, right? Because essentially, an LPA allows you to appoint proxy decision makers in advance. We call these proxy decision makers donees. So these donees, they will be vested powers to manage your financial matters, to manage your personal welfare decision matters, and essentially apply your own resources for your own welfare, or even to improve your own quality of life in the event that you lack capacity, and also make personal welfare decisions in a manner as if they are an extension of your personal autonomy. So that's my summary.
Thanks, Shankiat. Okay, then Dr. Liana, finally. So Dr. Liana, for an LPA, right, we know that it can be certified. You can do it and certify it by a psychologist, right, a practicing lawyer, but also a doctor, right, an accredited doctor. So I have two questions then for you. What is the role of doctors in certifying the LPA? Can any doctor do this? And then second question is, can you tell us a bit more about how doctors assess mental capacity or loss of mental capacity, right? Which is when the LPA kicks in.
Okay, thanks, Arita. And thanks, Shankiat, for helming the conversation for so long. Yeah, so have a good drink. Yeah, so I think we'll take one step back to talk a little bit about the people who can certify an LPA. So as Arita mentioned earlier, lawyers can, psychiatrists, not psychologists, can, because psychiatrists are the physicians, and specific doctors can. So a point to note is all doctors can assess for mental capacity, but not all of them can sign off on an LPA. There is a list of accredited doctors, and you can find this actually on the OPG website, so Office of Public Guardian website. So if you're looking to find a doctor, you can go there and they have an updated list for you to look through. What's really important is what is mental capacity? I think that's a term that you will hear quite a lot, but I hope that we can make it clear what actually it is. So mental capacity is, in very brief terms, the ability of somebody to make decisions for themselves. And an important thing to realize is mental capacity is decision specific. So for example, if I have an elderly patient who has dementia, he may be able to decide what he wants to eat for lunch, but he may not be able to decide how to distribute his assets and finances. Or he may not be able to decide how whether or not he wants to consent to go for a particular surgery. So we have to remember that we have to assess the mental capacity in the context of the decision that they're trying to make. Yeah, so that's something important to realize. And an LPA, in creating an LPA, the person who creates it, or the donor, must have mental capacity at that time when they're creating it. And the LPA only comes into effect when they lose this mental capacity. So when we go back to trying to understand how to assess mental capacity, this is something that most of the physicians, all of the physicians actually are able to do. There are different parts of the assessment that needs to be made. Sometimes the assessment may not be made in one sitting. So don't be surprised if you bring your elderly relative to a physician and they may not be able to sign off straight away. They may ask you to come back again another time to make another assessment. And the reason for this is there are different parts of it that have to be fulfilled. The person who is receiving the information has to understand what is being conveyed to them. So what is this information that they are receiving from the doctor or the psychiatrist or the lawyer? They have to be able to retain the information. So there has to be a memory component to it. They have to be able to weigh the decision. So exercise some sort of calculation or reasoning behind making certain decisions. And lastly, they have to be able to communicate the decision back to the person giving the information. And only with all of these sort of components fulfilled, then we can say, yes, this person has decision-making capacity for this specific decision. Most of the time, for younger clients or younger patients, we tend to assume that most of them do have mental capacity. This starts to come into question if there is a reason for us to believe that there might not be. So if I have a young patient who had been in a traumatic car accident and had some head injury, so he may be somebody that even though he's young, I may want to do this assessment. Or an elderly patient, like what Shenkiat says in his firm, patients above 80, we even though they have no medical history, we always, on the side of caution, sometimes we will do this assessment as well for them. Yeah, so I hope that answers the question.
Yeah, thanks, Dr. Liana. Excellent points that you've raised. Sticking with you again, to be fair, right, to you, because Chen Chen monopolized a lot of the time, right? So okay, so sticking with you again, can you tell us from your doctor's perspective, right, in a hospital setting, right, what is the difference in terms of the how doctors, treat a patient for a patient who has lost mental capacity but has an LPA versus a patient who has lost mental capacity but does not have an LPA? Is there a difference, or what do doctors look up for in both scenarios?
Yeah, that's a very actually very good question. And of course, if any of our patients have LPA, it is to our advantage and to their advantage that we are aware of it. So if any of your family members, have an LPA, and then they come into hospital for some reason, are unable to make decisions, they're confused, or touch wood, they've gotten into an accident or had a stroke, please let us know if you do know that your family member has an LPA. In a hospital setting, actually, the more pertinent section is the personal welfare section. So as we know, there are two parts to the LPA, the personal welfare, and then there's the property and the financial part of it. So for the personal welfare part of it, it's a little bit more relevant to medical practice. To preface all this, regardless of whether or not you have an LPA, the doctors who attend to you, the medical providers who attend to you, will still contact the next of kin if you are unable to make your decisions. And the discussion process on the treatment plans and what comes next still will involve the next of kin. Where the LPA is really helpful to us are for patients who have no very clear next of kin. So for example, if you have an elderly gentleman or lady who lives alone and they made an LPA so that their good friend or their neighbor is their LPA. And with this information, we know who to contact, who they trust to be their proxy decision maker, and who knows them well, so that we can make collaborative decisions together. Yeah, there is a certain clause in the LPA where if it is marked off, that means if it's specifically indicated that the donee will be able to sign off on consent or refuse medical treatment. But this only applies to treatment that is not life-saving. So if we think that the patient should be put on a ventilator or brought to ICU, no matter if you have LPA, you don't have LPA, you cannot refuse on the behalf of this patient who has no capacity. Yeah. And this treatment cannot interfere with serious illnesses with serious outcomes. Yeah. There are a whole list actually of things that the LPA donee has power or has no power over in terms of the personal welfare. And actually, a lot of the details can be found in some of the resources that are in the Dropbox as well. Yeah, so roughly that is some of the benefits that the LPA can bring. But by and large, a lot of the treatment options and the treatment process still will follow what is the most medically indicated for the patient at that time, and will still be in collaboration with the family.
Thanks, Dr. Liana. I think it's still very comforting, right, to know that doctors will always act, I guess, in the best interest of the patient, I think is what you're referring to, right? So it's good that, you're not just, your life is not just in the balance just because an LPA or your donee decides that the checkbox is more important, right? Okay, so maybe let's move on then quickly to the next topic, which is Advanced Medical Directive or AMD. Sharket, again, really short, right? Just explain. Can you just explain what's an AMD and how do we make an AMD?
Sure. Very quickly, AMD is a legal document that you cannot make with lawyers. You can only make with doctors. All right. That basically states that in the event where where these 5 prevailing conditions are in existence, right? So mainly the patient must be terminally ill, facing imminent death, no hope of a permanent or temporary recovery, is in an unconscious state or unable to make a rational decision, then no extraordinary life-sustaining support is to be applied. So it basically covers a very, very narrow spectrum of medical decision making, right? Because you need to be terminally ill. And I guess that's really all I have to say for AMD.
Okay, great, Sharket. Thanks for keeping to the time. Dr. Liana, then since an AMD is a legal document, but it's only certified by, you can only do it before a doctor, right? Then as a doctor, then what is your experience with AMDs? Is this something that is common amongst patients that you see or something that is becoming more common? And also, what advice would you give to a patient who is, let's just assume mentally sound, capable of making decisions? What advice would you give to a patient like that who is considering doing an AMD? Doesn't have a terminal illness yet?
Okay, yeah, so there's quite a number of questions there. Let me just try and get through them one by one. I think the first question is how common is it and what my experience has been. To be honest, it is back to what the AMD is. It's very easy to enact to sign off on an AMD. So to create an AMD is not difficult, but to invoke an AMD is actually a very long process. And that becomes the limitation for the use of the AMD. So I'll go into a bit of detail about that later. But a lot of the times, my patients, within the patient pool that I look after, not many of them do sign AMDs. Surprisingly, many doctors sign AMDs. So we often see our colleagues who sign off on their own, who sign off on AMDs for each other. Yeah. So how often have I seen it in practice? I have never seen it in practice, not in the 11 years of practice that I've had. And the reason for this is what I mentioned earlier. To invoke it is actually quite limiting and quite a process. So to invoke it, just to give you a rough idea, I have to fax off a form to a registry. First of all, I'm not allowed to ask a patient or family if they have it, so that it does not bias my treatment of the patient. If I think that this patient is a suitable, fulfills the criteria that Sharket mentions, I have to sign off a fax, which will then be replied. I have to find 3 colleagues of mine who agree that this patient fulfills the criteria. We send off a second form, which will then be replied. And then we decide at that point, okay, we are not going to apply any life-sustaining measures. So this office where we fax to, you can imagine it's only during office hours. So if a patient comes in the middle of the night, collapsed, there is no time for this whole process to unfold. Most of the time, in groups of patients that we see who fulfill this criteria, if they have a terminal illness, if they are unconscious, and there's no hope for recovery, the decision that we would recommend would not be different for an AMD. So we would not recommend life-saving treatment for somebody who's terminally ill, who has no hope of reversibility, who's unconscious, in a coma, unable to make a decision. And so that already kind of, it makes the AMD a little bit less used than other modalities. So my advice to people considering an AMD is definitely your prerogative. If you feel that this helps you to feel better about not going through certain processes, you can go ahead and make it. But the challenge is that just because you make an AMD, it is not guaranteed that you will never be put on a ventilator or you will never have CPR applied to you, because you may not fulfill all the criteria. So for example, if you're unconscious and you cannot make a decision, but you don't have a terminal illness, and we think maybe this is reversible, you may still end up on a ventilator. You may still end up with CPR done. So that becomes the challenge. So if it were my family member, my preference or my recommendation would be, if you're going to invest in a tool, that maybe another tool might be a little bit more readily accessible and might indicate your preferences a little bit better. And that tool will be the ACP, which we'll talk about later. But yeah, at the end of the day, it is still your prerogative to make an AMD. The doctors, all doctors will be able to help you with that if that is what you choose. Yeah.
Thanks, Dr. Liana. Then on this point, we hear these words, terminal illness, right, always being used, right, for an AMD. Can you explain what does it mean from a medical perspective, right? As a doctor, what, you're talking about the 3 doctors who have to unanimously agree, that the patient is terminally ill and all the other conditions, right? There's no reversibility, as you mentioned. But then how do doctors make the assessment whether a person is having terminal illness? Is there a specific kind of disease that you need, or what is it? Do you need to be in a persistent vegetative state, a coma? What is, how do doctors decide?
Yeah, I think this term gets thrown around quite a lot. I think sometimes you hear it with insurance agents also, like critical illness and terminal illness, like what is all this that everybody's talking about? So as a doctor, a terminal illness is an illness for which there is no cure. Yeah, so a lot of times when people think of terminal illness, they think of something like cancer, like very advanced cancer that spread to many parts of the body. So yes, that's one kind of terminal illness, but there are many things in the body that can go wrong that cannot be solved or cannot be reversed and cannot be cured. So things like organ failure. So if you have kidney failure, heart failure, or if you have very severe trauma, that can also be terminal. For example, if you get into a terrible road traffic accident and you have severe brain injury, or you have a massive stroke and you can no longer breathe on your own, that means your brain is no longer supporting any of the body functions. So this is something that can be considered terminal as well. On that point, I know that some people in the past have asked, what is brain death? Is that also a terminal illness? So in brain death, your brain no longer supports the body functions that allow you to remain alive by itself. So your brain controls your breathing, your heartbeat, and everything. When you are brain dead, your heart will stop beating and you will stop breathing because your brain doesn't function that way anymore. And so in that sense, yes, it is also a terminal illness, and the AMD would apply for these patients as well. Yeah.
Thanks, Dr. Liana. I think you made a good point previously, right, about, instead of an AMD, maybe there are other ways, right, like the ACP that you mentioned, other ways to kind of touch on the same topics, but maybe not using an AMD. So what you referred to is advanced care planning, which is our next topic. So Dr. Liana, advanced care planning, this is it's a healthcare related, a medical related point. Why don't we start with you? What is an ACP?
So yes, an ACP is the only tool that we're going to talk about that's not a legal document. So there's nothing legal about this document, but instead it's a document that helps you to indicate your preferences And these preferences are namely how you want to be treated in certain circumstances medically, and also who do you wish to speak on your behalf in the event that you cannot speak for yourself. So you can see that there's a little bit of mirroring with the LPA, where you make this ahead of time when you still can, and when you can't anymore, that means you can't indicate your preferences anymore, then somebody you've identified already gets to speak on your behalf as well. So the important thing about ACP is usually it's done in conjunction with the person that you choose as your spokesperson or your nominated healthcare spokesperson. So it's not done in isolation. In an LPA, you can actually just go to the doctor or the psychiatrist or the lawyer on your own, and the person who you nominate need not be there. But for a ACP, the person who you nominate should be there as well throughout the discussion. The other difference with the ACP also is that there are several kinds, and within the several kinds of ACP, there are additional discussions about what makes you come to these decisions about your preferences as well. And these are usually documented along with the ACP document, so that in addition to your preferences, we have a bit of background to understand how you came to these decisions for yourself, and how do you weigh out what's important to you and not. Yeah.
Thanks, Dr. Liana. Dr. Liana, then in this case, right, speaking of the ACP, you mentioned that it's not a legal document, right? So, but the thing is, how would the doctors or the hospitals, right, have access to what you've written in your ACP, right, regarding the way that you want your different aspects of how you want your healthcare care to be done by the doctors? Is there a central depository? You know, how would doctors have access to this? You mentioned like for AMDs, doctors cannot see, right, for ethical reasons, right? But for an ACP, then are the doctors able to access and know?
Yes. So the ACP is actually tagged onto your National Electronic Medical Healthcare Records. So no matter which hospital you go to, as long as you've done an ACP, it will be uploaded, and we are able to check at that time if there's one done before, when it was done, and what are the outcomes of it.
Thanks, Dr. Liana. Can you also then explain the previous point that you mentioned about the fact that the ACP might potentially cover some of the issues regarding the issues covered by the AMD, right? So would you be able to indicate in your ACP, instead of using the AMD, whether you want to have life-sustaining support once you are no longer able to support yourself? Is that something that can be done?
Yes, definitely. So maybe, Sarita, I can just quickly go through a little bit of detail about the ACP, because there are 3 different kinds, and I think different patients fall under different categories. So there's a general ACP, a disease-specific ACP, and a preferred plan of care. So these are 3 groups of patients with 3 characteristics. In all these kinds of ACPs that are done, all of them will have a section that indicates if they are in a situation where they're terminally ill and it is irreversible, would they want life-sustaining treatment for themselves. So regardless of which ACP document you fall under, there's an indication for this. The benefit is that in addition to the indication for this, you get to say why you chose it. So why do you not want life-sustaining measure, or why do you want life-sustaining measure? So that we understand also the thought process and the values that you have for yourself in making this decision. So if I could just quickly talk about each of the ACPs. Yeah. For the general ACP, it's really about healthy individuals or patients who have very mild illness. And the aim of this ACP is actually to begin to think about your values and preferences. So this ACP can be done with a facilitator. There are a group of healthcare professionals who are facilitators. They may not be doctors, they can be nurses, they can be psychologists, they can even be social workers who are facilitators. So they can be, this general ACP can be done with a facilitator, or there are actually even workbooks where you can just do it on your own at home and share it with your family members. The next type of ACP is a disease-specific ACP. So these are for specific chronic diseases. So for example, if you have lung disease or you have kidney disease, and these ACPs are done usually in a specialist setting. So when you see your specialist lung physician or a specialist kidney physician, they may recommend that you do this. And this is actually because we want to talk about certain treatments that are very specific to their illness. And what are your thoughts about it? The last one is a preferred plan of care. And in this last ACP, these are for patients who have what we estimate a year or less left, and they have an illness that is life-limiting. And this last ACP deals a lot in detail with goals at the end of life. So what are certain treatments that are important or not important, necessary, not necessary, and very importantly, what are your preferences? Where do you want to be cared for? If you have a choice in it, do you have a preferred place that you want to pass away? So these are all the things that are indicated, so that whichever healthcare professional comes across your ACP has an idea of what you wish for yourself, and we do our best to to fulfill that wish for you. Yeah.
Thanks, Dr. Liana. Then on this point, right, regarding the ACP seems like it's a more detailed kind of planning document, right, for how you want your medical needs or healthcare needs to be, to be done, right, to you. Going back to an LPA, right? What is the main difference between the personal welfare part in an LPA versus this using this nominated spokesperson versus using a donee for the LPA?
Yeah, so I think a donee for the LPA has a lot of times what we do see is that they are the same person. Most people would choose the same person to represent them across the different tools. But in terms of how it differs, a nominated spokesperson, what we hope or what we understand is that they have a lot of insight into why these decisions are made. Because as much as we would like to discuss preemptively everything that can potentially happen to a person and whether they would want it or not want it, there are things that are unpredictable and unforeseeable. And in the discussion of the ACP, because we not only focus on what they want and don't want, but what are their values and what are the values that underline why they choose this, or their experiences that underline why they choose this or not. This nominated spokesperson may have a little bit more insight into if there's something else that wasn't specifically discussed. Based on the values that were discussed, what do you think your loved one would have wanted? Yeah, so that I feel is the difference between the donee as well as a spokesperson. But by and large, what I've noticed is that if there is an LPA and an ACP made, by and large, they're the same person. Usually the person that you trust will be the same person for both. It's not often that we see that they're different people. Yeah.
Thanks, Dr. Liana. Then what the other question is also related to ACP, but it talks about ACP in a critical or time critical situation, right? So the question is, in the event of a medical crisis, when an individual is rushed to the A&E, right? Is there time, right? How long does it take to retrieve an ACP from the EH medical record system? Yeah, electronic health and medical record system, right? How long does it take before medical intervention is done on the individual? This is a A&E situation, right? So maybe someone is already unconscious, losing a lot of blood. Do the doctors wait to retrieve the information from the ACP, or do they, like what you mentioned earlier, do they just act in the best interest of the patient at that time, right? Because time obviously is of the essence in that case.
So in this situation, if you've ever been in an A&E, you know that a lot of things are happening at the same time, and it looks like chaos, but it's organized chaos. So what will happen when somebody comes in A&E in an emergency situation is there won't just be one person attending to them, it'll be a team. So one member of the team may be the one looking up the history, including things like the ACP. There are other members of the team that are standing by to start the medical treatment. And so we won't compromise one or the other. So we won't be waiting for the ACP and not do anything until we get the ACP. And at the same time, we won't start medical treatment and just later, like half an hour later, then, oh yeah, maybe we should look for an ACP. That being said, retrieving the ACP actually is very quick. So all our systems in the hospital are linked up to the electronic healthcare records. And so it takes minutes to retrieve an ACP if one has already been done. Yeah. Another way, if you are very worried that we may not get the ACP in time, and it's important for your family members, is you can always ask for a copy when the ACP is done, and you can keep it with you. And so if your loved one comes to the hospital, you can give it to the paramedics, or you can give it to the doctor immediately and say, he has an ACP. So if that's something that you're really concerned about. Yeah.
Thanks, Dr. Lena. Okay, so maybe why don't we officially move into our Q&A section, right? So let's again, Shanket, so you're back online as well. I think your timeout is enough already lah. So let's go back to discussion. Okay, so like I mentioned earlier, there's a lot of questions relating to wills. So let me just see a couple that we haven't dealt with before. Okay, so one of the questions then, Shanket, I think this is for you, right? The question is, what happens to the assets if there is a will, but the executor cannot locate the beneficiary? Then what happens? Is the executor supposed to just hold on forever? How long do they need to hold on? Is there a way to apply to court? How do we deal with this situation?
Right. This is a really good question, and it's actually more common than we thought. I guess the first question, sub-question would be that the court will still grant court order, right? Grant of probate to this executor if there's a will, right? Even though the beneficiary is not, you can't locate or identify the beneficiary. The main issue that the executor in this case will need to take note will be his or her liability, right, in discharging the estate. Should he or she, in their capacity as a personal representative, hold on to this portion, right, for this beneficiary for a determined period of time, or should they, treat the beneficiary as potentially deceased and then distribute? Generally speaking, what most lawyers would say is get an indemnity signed by all the prospective beneficiaries, right? So that in the event if you as a personal representative, you had diligently done your duties, but somehow this beneficiary pop out in the future, then at least that gives you a basis, right, to make clawbacks from these other beneficiaries. But that said, that's not a foolproof solution, because the beneficiaries may have already spent the inherited sums that were given to them, and you're still liable. So to that extent, we actually have this not very well known court order called the Benjamin Order. Essentially, the Benjamin Order allows the executor, right, to ask the court to issue such an order and to direct them on how to distribute assets. So essentially, if the court says, yeah, you can treat this person as having been deceased, or you can treat this person as unidentifiable, you hold the asset for 7 years. If they don't turn up, then you feel free to distribute according to how the will have treated this person's this missing beneficiary share, right? If he or she will be deemed to have like predeceased. So the main difference between getting an indemnity signed by other prospective by the beneficiaries versus getting a Benjamin Order is essentially that Benjamin Order saves you, right, as an executor, because it's court directed.
Thanks, Shanket. Again to you regarding distribution. The next question is, for a property that is held under tenancy in common, so you have A and B, right? The tenants in common. How is the distribution done at the time of death? For example, must the executor sell off the whole property, it's a property, right? So even if you're tenants in common, you can't split, you can't split the property, right? So must the whole property be sold off and then the proceeds kind of divided in that way? And also a follow-on to this same question is, what if the market conditions are not so good, right? And then you're not getting, even if assuming that you have to sell off the property, you're not getting that good a price as maybe if the market was a bit more buoyant, right? Then is the executor still forced to sell the property, or can they wait until prices go up?
Very good question, and there are many layers to this question actually. I guess the first will really be, we need to make it clear that the personal representative, aka the executor or the administrator, right, that isn't a will, they are supposed to act in the best interest of the beneficiaries, right? So that is the number one rule, right? If it's well, for property under tenancy in common, if it's a HDB flat, essentially the hands are tied, right? Because prevailing HDB rules will apply. If it's a private property, then there might be some leeway in how this property is to be dealt with. As part of estate administration, which is the process after obtaining a grant, that means the court, aka the court order, to transfer a property, that essentially two steps, right? The first step is what we call transmission, and the second stage is what we call transfer, right? At the transmission stage, essentially the property is transferred from the deceased name to the name of the executor in their capacity as executors, right? So they are free, they have legal title, because you need legal title to deal with the estate. As to when the legal title then moves on to the beneficial owner, right? Then that will be dealt in the second stage called the transfer. So there is some flexibility for the second stage, right? As to when the second stage should happen. But that said, we have to look at the will and see what the powers that are vested to the executor, right? Does the executor have any powers to hold this property on trust for a period of time and be protected against any potential issues, right, that come from the beneficiaries? Or is it a straight, I need to sell this within a one year anniversary of the death of the testator? So we do see wills that actually stipulate a time frame. But let's say the will is silent, we generally advise clients to do it within a year or two. If the will has a very well-defined trustee powers, then there is a bit more flexibility. So in the event where there are, say, there might be a surviving co-owner, right, who might be reluctant to sell, then it's really a balance of interest, right, between that of the surviving co-owner with the rest of the beneficiaries. So that is something that has to be looked at based on the facts. But I think my only conclusion to this would be that it's not necessarily a majority rule kind of situation. It's not the person with the greatest percentage of ownership in the property have the bigger say, right? There are a series of actions that can be taken to make sure that if a sale is compelled, it's in the best interest of everyone.
Thanks, Shinket. Dr. Liana, let me ask you some questions as well. Okay, so the first question, I think you did touch on, what terminal illness can cover, right? But this question also touches on that point. So the question is, does terminal illness include dementia and I guess Alzheimer's as well, right? Since both of these conditions have no cure, right? And they're not reversible.
Yes, to an extent. So a lot of conditions are not black or white. So they exist in a spectrum. So for example, kidney disease also exists in a spectrum. If you're an early kidney disease, it might not affect your lifespan, but if you have very advanced kidney disease, then it will affect your lifespan. From a perspective of dementia, it's the same principle. So in early dementia, if the patient remains in early dementia for a long period of time, then they might not change their lifespan too much. But we know that dementia will progress. And so towards the advanced stages of dementia, it will affect your lifespan and it will cause you to have signs and symptoms that can shorten your life as well. So in advanced dementia, yes, it is a terminal illness. Yeah.
Okay, Dr. Liana, then this is a question I think some of our audience members, including myself as one of the panelists, right? We're curious, right? You mentioned that for AMDs, it's mainly doctors who do this, right? So knowing that you need your 3 doctors, 2 of them have to be specialists to certify. Why is it so popular? Why is the AMD so popular amongst doctors? Since it's a bit of a hassle to actually enforce it.
It is, and I think that nowadays I see it done less and less in general. But I think this observation that I have had been something that existed prior to the inception of ACP. So ACP came about somewhere around 2010, 2011. That's when it first started. And so and I've been practicing or I've been in the medical line from before that as well. And so that's where a lot of what I've observed, where doctors see the outcomes of patients who are put on life support or who go through life-sustaining measures, even though their disease is irreversible, and even though we know that it will not change the outcome, and most of doctors don't want that. And so this was the next best at that time. And as ACP comes in and starts to pick up more steam, generally the attention has shifted also. So yeah, I mean, that was an observation earlier part. Probably now, I don't think, even for physicians, not as much would do the AMD, and more people are taking up the ACP instead.
Thanks, Dr. Liana. Okay, then Shen Kiat, let's go back to you again. So this question is a question about disputing a will, right? So in this scenario, specific scenario to husband-wife case, but I think it can be anybody, right? So I'll make it a bit more generic. What if a person makes a will and gives his or her assets to someone who, not the children, not the spouse, right? Can the children or the spouse then contest this will?
It's a good question. No easy answers. The short answer is yes. It can be contested. In the sense that our legislation under what we term the Inheritance Family Provision Act, it's mandated that husband or wife needs to provide for their families, right? So if they did not leave anything for their spouse or their children, or under what we define as a family member under this legislation, then they can apply to the court to make a determination on what is fair, right? To carve out from the estate to be distributed to these family members that have been excluded. And then the rest of the estate will then follow the validly executed will, right? So essentially, my point is a will can only be contested on a few bases, right? That it was made due to lack of capacity or due to undue influence or duress, right? But outside of this, let's assume that the will is validly executed, there is still recourse to the family members under this Inheritance Family Provision Act. As to how much, the court will look at the facts, right? Have the family been provided for during the lifetime of the testator? Have the, for example, have the family members be all bequeathed, right, a property of their own, some monies already in their bank accounts given to them by the testator, so on and so forth. So it's on a global sum basis that the court will look at all these things. But there is some recourse, but the outcomes may not please everybody.
Thanks, Shen Kiat. I think it's quite interesting because on this same point, right, regarding the dispute, there's a flip side question. I think it's a very interesting kind of question, and I would love to see how you deal with this. So the question is, can a testator put something in the will, right, to prevent beneficiaries and non-beneficiaries from complaining about how the assets are distributed?
Sarita, you're asking questions that basically making us let out our trade secrets, so essentially, right, I think this question probably arises because maybe the member audience might have seen the will, right, that says that, if any of my beneficiary contest this will, then the gift to them might be disregarded and they will get nothing under my estate, or they'll get a nominal $1 in my estate, right? Essentially, let's just say, even if these clauses are workable, there are ways to get around it, right? There is a way to challenge a will without actually challenging a will. Right. So for example, just now I mentioned, if you want to challenge a will based on its validity, that will, it is due to mainly lack of capacity, undue influence, or a duress, right, or fraud, right? But let's say I am not challenging the will. I'm trying to clarify the interpretation of the will, right? And I put what we term the originating summons, which is basically asking the court to form a determination on how a particular clause is to be interpreted. That is an indirect way of like trying to maybe get a more positive interpretation, right, to the outcome. So I would say that it may be helpful to put such clauses in because it increases the barriers to a challenge, to a successful challenge, I may add, but it does not stop it completely.
Thanks, Shen Kiat. Okay, so another question relating to formalities, right, for a will. So the question is, for wills, what happens if a testator doesn't read or write English, right? Or is only literate or can speak Mandarin, for example, right? How would you get the witnesses, or are there lawyers who can witness if, let's just say, they are fluent in that language, for example?
Yes, of course.
Does it impact how you do the will?
Yeah, I think generally lawyers like myself, we prefer to witness wills that we have drafted. We tend not to like to witness wills that are done by other people, right? But that said, if someone is Mandarin speaking or maybe English speaking, but signs in Mandarin characters, right, or Sanskrit or whatever for the matter, we generally will need a attestation clause that says that they are versed in a particular language, and this document has been interpreted to them. At my end, at my firm's end, we generally will say that the testator understands English. Some of my clients say, of course I understand English. Why do you need to put that in? But really, sometimes the judge will look at the will and say, hey, it's a Chinese signature, or it's a signature that doesn't look like it's English, right? And we can't take it for granted that the testator understands English. So yeah, so these are the things that we do. I must say that also for people who are blind, right, they also have special attestation clauses as well. So basically for the lay people, right, attestation clauses basically deals with the description of the testator, right, of the person who is signing the will, right, and what have been done to make it known to them that they understood the contents of the will, right, before they sign, and who are the ones involved in making this note. So yeah, that's my short answer to the attestation clause. Actually, sorry, if you don't mind, I see a question on the bank accounts, joint ownership bank accounts. I would like quite quickly to address that, because it's also a very common question that I get. Yeah, so for bank accounts, yeah, so go for it.
So sorry, let me just introduce the question for our audience. So the question is, what happens to a jointly owned bank account, i.e. both account holders must sign for withdrawals, in the event A, one loses mental capacity, or B, someone passes away?
Yeah. Thanks, Sarita, for you're the best moderator, man. Yeah. So essentially, so if in the event where a bank account loses capacity, right, then and if the LPA is being made, then the LPA will need to be activated. That's when doctors like Dr. Liana will come into play, because then they will have to write a medical report to state that the account holder who lacks capacity to manage their financial affairs, right? So to gather a medical report, and the LPA will then go to the bank, right, and in your capacity as a donee, and take control over the account and manage it, right? So it's normally a one-off procedure in that sense. So if it's an account that requires both parties to sign, the donee will be able to represent the party who lacks capacity. If it's either or joint / alternate kind of situation, either party can withdraw the monies, right? Actually, in this condition, there's just one important point I really want to address, which is that for jointly held bank accounts, we need to make the differentiation between what is legal ownership and what is beneficial ownership, right? Legal ownership is basically whose names are on the account, whose names are on the people, right? Beneficial ownership will be who is actually the ultimate beneficiary of the accounts, and I think there is a difference to be made on that. Yeah.
Okay, thanks, Raket. I think we have to do speed round now, right? So speed round, yes or no only. Okay, so we have 3 questions for the speed round. The first question is, can an executor of a will also be a beneficiary?
Yes.
Okay, good. Okay, then the next question is, can a minor inherit HDB property or any other property through a will?
Yes, but the property will be held on trust for a kid until they turn 21.
Okay, and then last question then, must a will be in writing, or our audience members are very creative, can a will be done through video since it's a digital world, right?
It cannot be done through a video.
Okay, then great. Okay, so yeah, we must bring to our audience members, we must bring our Q&A section to a close. We've had a lot of questions. I think we've managed to address most of them. Before we officially end, maybe I'll ask both our speakers to just take about a minute or so, right, to just speak about the one the one absolute point, right, that they want the audience members to take away with them. So maybe Dr. Liana, let's start with you.
Okay, my one absolute point. It's very hard. We had a lot of points today, and I think a lot of very good questions as well. So if I could make a plea to everybody who is listening, what I would like to say is to start the conversation early with your family members. At the end of the day, the tools that we present are really just tools. And it's only as good as the knowledge and the background behind it. So I know it's a difficult conversation. I know it's taboo, but if you can find a way to begin having these conversations with your loved ones, whether it be your children or your parents or somebody you know and you care about, that would be what I would hope you take away from today, that it's always better to start early, to speak early, and then from there you can see how it goes.
Shankiat, what about yourself?
Well, I guess we talk about so many different instruments, right? The main point I want to make is that all these instruments, they are both independent and they overlap with each other. You should really see them as a total defense, right? If you make an LPA, you make an AMD, you make an ACP, you make maybe even a will as well, you should, it ensures that a consistent narrative runs through, your regards to how your intentions are to be interpreted. Right, so while they can stand alone, they can be seen together as total defense. If you are paralyzed as to how should you start and where should you start, I have a very straightforward answer. Start from an LPA, really, because if you die, you die. But if you lose capacity, you could have a longer runway, right? And think about it, you want to make life easier for a caregiver, right? So support your caregiver to give better care for you, really. Just start from LPA and then make ACP part of it. That should be the first thing that you should do.
Excellent, Shankiat. Thanks, Dr. Liana, as well. To audience members, we have to bring our webinar to a close. Please scan the QR code or visit the QR code on your screen right now, or visit the website cdc.gov.sg/Law Awareness Weeks to find out more about the other webinars that will be held under our Law Awareness Weeks. Please remember that relationships are precious and we should heal relationships with those around us. After this webinar ends, a feedback form will be shown on your browser for your completion. We would greatly appreciate if you could just take a few minutes to complete the form so that we can improve our webinars. And with that, thank you so much, Dr. Liana, Shankiat, all our audience members, right, who have stayed with us for slightly over 90 minutes now, for joining us today, and have a pleasant week ahead. Take care and keep well.
Thank you.